AI can be a wonderful tool. It appears that it was misused here. I think it represents a fraud on this court. Of the 6 cases that Mr. Karachi relied on, not a single one of them actually stands for the proposition that he cited it for.
It was simply a clerical error.
You start making specious arguments. I've heard enough. Going to find.
This pro se litigant is not a lawyer, but he
did stay at a Holiday Inn Epxress last night.
He's flying dangerously close to the sun, though.
I'm learning procedural law on the fly.
And Judge Allen picks up on that right away.
You might be about to get yourself into trouble. If you're practicing law without a license, there are rules against that.
He filed a motion that is complete balderdash, clearly written by an AI. This trend is alarming. In fact, I've covered 3 such cases in the last week. Judge Allen may be low-key, but his ruling leaves no question as to who'll be paying the price. Let's moments.
So it looks like he's ready to argue a motion. Have you spoken to him about what he's going to argue?
I have briefly, and I was actually expecting him to be on Zoom. I was going to ask you for a breakout room, but I don't know how that would work at this point. So,
a very pointed question. Are you in opposition to the motion that he's going to make?
If it's yes, I am. Yes.
Okay, then there's really no point in us having this sort of bifurcated then. Let's let him do what he's going to do, okay? And of course, you get to respond to it. And then what will happen is once you respond, then I'll go back to him for his response to what you say. Okay?
Okay.
Go right ahead, counsel. I guess we should first get your appearance for the record.
Thank you, Your Honor. Joseph Cooper here on behalf of the defendant Robert Adato and Adato Trailer Sales and Service Incorporated.
Mr. Adato, you can have a seat. You don't have to stand next to her.
Oh, thank you.
Go ahead, Mr. Cooper.
Well, Your Honor, just to start with a couple of housekeeping issues, Mr. Karachi's reply brief stated that he expressly withdraws and disclaims any personal claims for breach of express or implied warranties, UCC remedies, or any lemon law type statutory relief. I believe that equates to counts 2 and 3 of the plaintiff's complaint. So I think that there's agreement that counts 2 and 3 should be dismissed.
Let me just ask Mr. Karachi if that's true. That's true, Mr. All right, counts 2 and 3 are dismissed.
Thank you, Your Honor. Regarding just one other housekeeping matter, we had filed a motion to dismiss for failure to name the real party in interest. Mr. Karachi had filed a response brief. We had filed a reply brief, and in our reply brief, we had requested sanctions against Mr. Karachi. Mr. Karachi had also filed a motion to substitute parties and had filed afterwards. Mr. Karachi filed a motion for substitution of parties and a motion for a protective order, but neither of those were noticed for today. So I believe that only my motion, only my 2 motions are before the court today. The initial motion is a very simple one, Your Honor. Peter Karachi was not a party to any transaction with my clients. Highbox LLC, which we believe to be Mr. Karachi's limited liability corporation, was a party. And yet Mr. Karachi filed this complaint in his own name. I dove into some of the law on this in my motion brief. It's MCL 600.2401 and MCR 2.201B, and it's the Weston and Dowdy case that's on point. It's a very simple motion, and I believe that the law is on our side and the court should grant it. However, I do want to take a moment to say Mr. Karachi's response to the motion is the other reason why we're here. AI can be a wonderful tool, but it appears that it was misused here to the extent that I think it represents a fraud on this court and required additional attorney fees. I believe that Mr. Karachi signed his response in violation of MCR 1.109 E5 and 6. of the 6 cases that Mr. Karachi relied on in his response brief, not a single one of them actually stands for the proposition that he cited it for, and one of them appears to be a completely fictitious AI hallucination of a case. Unfortunately,
AI could hallucinate.
well, yes, Your Honor, it's pretty common. It's there have been sanctions given in multiple courts, federal courts in particular, for violation of Rule 11. It literally invented a case that does not exist. I went into detail in this in my response brief or reply brief. He cited a case that just plain does not exist. The citation that he used, there's another case for it. I did an exhaustive search trying to find a similarly named case. No such case exists. And frankly, this gets back to the reason why the initial motion should be granted as well. Certainly, litigants have every right to represent themselves in court. However, no one has a right to represent a corporation that is not an attorney. And the AI issues is just one point for why the complaint should be dismissed. Mr. Karachi misinterpreted Michigan lemon law, claiming that it was relevant to trailers. It's not. It's only relevant to motor vehicles. He claimed emotional distress damages for a contract dispute. With respect to Mr. Karachi, I think that this complaint needs to be dismissed so that Mr. Karachi can have the advice of an attorney, and if they believe it's appropriate to refile, it should be refiled. Mr. Karachi should also be held liable for the additional unnecessary attorney fees he forced my client to incur in replying to his what appears to be an AI written motion response.
What would be the attorney's fee?
Well, unfortunately, Your Honor, because I'd have to include my time here today, I don't have my statement today. I'd ask for an evidentiary hearing to be set. Frankly, I would hope that once that evidentiary hearing was set, that we might have a better opportunity to settle this matter so that it wouldn't be necessary. In my previous effort to settle, I'll say that the response that I received was
Uninformed?
laughably insane, Your Honor, and I don't say that lightly.
It's uninformed.
It was certainly uninformed. We made a generous offer to settle this matter, and Mr. Karachi came back demanding double what it's.
That's your opinion. Sir, you have the floor.
Hi, Your Honor. Hi, Mr. Cooper and Mr. Adato. Firstly, as far as the motion for sanctions, yes, I do use.
We don't actually get to sanctions unless I grant him the relief that he's asking for. So you might want to argue that he should not be entitled to the relief at first blush, just to see if I agree with you.
Yeah, I do not. Thank you, Your Honor. So I do not believe that he should be entitled to relief. It was simply a clerical error. I actually filed or wrote 3 different drafts, and I signed them myself. And when I went to file them, there was, somehow an error with the name. I can share my screen and show you, how I discovered it. But it was a clerical error. And there's nothing wrong with using tools. I mean, it's not against the law to use spell check or.
There is a very huge problem with using tools. You start making specious arguments, and when you make an argument to the court, there's an actual court rule that requires that it be grounded in good faith, that there's a basis for you to do that. And when you're using tools like what you're using, there is no basis to believe that the information that they're providing you is accurate. You don't even know where the information is coming from.
Your Honor, may I speak?
Sure, please.
Yeah, I mean, you're absolutely right. However, I do check all of my work. Again, it really was truly a clerical error. I know how to check the MCR and MCL Yeah, I know how to look up case law on, I don't have access to LexisNexis or anything paid, but Google Scholar is there. And that one should not have been filed, and I immediately remedied the issue, and there was no prejudice done to the client. It was a clerical error.
So you say that the attorney having to file a response and then coming to court to argue about it is not some sort of cost to his client?
I'm sorry, could you repeat that, the last?
Saying that the attorney having to review what it is that you put together, file a response to it, and then coming to court to argue about it is not somehow a cost to his client.
Well, I think, I'm sure there is a cost, but, I think that we are all, there's a cost to every action. And I mean, litigation is, I think, part of what an attorney does, and checking out all the sources and everything. And Your Honor, I filed the wrong motion, and
so there are actually rules and regulations that govern the practice of law, and that corporations are supposed to have someone who is steeped in the practice of law representing them. They're not supposed to just go and get some law student or some novice to represent them. They're actually supposed to have competent counsel to represent them. Because when you don't have competent counsel, it costs more to try and figure out what happened and what needs to happen as a consequence of what was done erroneously.
I do understand that now, Your Honor. I did not before. And when the merits of my case are very real. I don't know if this is appropriate to get into them now.
Second, because I'm having a little bit of misunderstanding here. The whole issue is that the real party in interest is not before the court. So it's not a question of whether it's your claim or not. You're not the real party in interest.
And
so there's a fundamental breakdown in the analysis when you start with that very real understanding. Who's the real party in interest? That's the person who's supposed to file the complaint.
And I am going to pull up MCR 2.201.
It's going to be very difficult for you to educate me. I've been doing this for a long time.
It is my understanding if the real party is not present, then there is the option to cure it with substitution of the real party.
You're at the point where he's already filed a dismissal of the case and he's already been heard with respect to that. I'm just giving you a chance to respond. So far, your response is coming up wanting.
Well, Your Honor, I did not realize, clearly, I'm learning procedural law on the fly as I go. I did not realize. Go ahead.
Plus, you might be about to get yourself into trouble. Because if you're practicing law without a license, there are rules against that.
Well, I may represent myself without a license, correct?
That's not what you're doing.
It's not?
That's not my understanding, not according to the argument that has just been advanced by Mr. Cooper. So this is your opportunity to respond to what he said.
Okay. Well, what I can say is that prior to signing all the paperwork that was started initially was in my name. It was Mr. Sean Stevenson who suggested I put it who asked me if I wanted to put it under a business name. I asked him if it would help build business credit, because that's something I would like to do with that particular business. And he said, it's worth a shot. So we went ahead and switched it. But prior to the signing of the contract, the misrepresentations were made to me, and the fraud in what happened was induced prior to the contract to me. And so that is why I initially said that I was the real party in interest. Now, if I don't fully understand Michigan law, and you are correct, it's very obvious I am a novice, but the merits of my case are real, and if you must dismiss it, I believe it needs to be done with prejudice, without prejudice. I apologize, so that I can refile, because with an attorney with the correct party.
Oh, he's also asking me to sanction you because the behavior is sanctionable.
Well,
You have to pay the cost of his filing fees as well as his attorney's fees, which would include any research time and the drafting of documents and his appearance here in court. And most attorneys probably earn about $150 an hour.
well, I mean, as far as the document, the improperly cited cases, again, I mean, it was a clerical error on my part. It was not something that should have been filed. It was the wrong document that was uploaded. Had I printed it out, and I would have, I think, been able to see it prior to putting it in an envelope. But I did look at the documents that I was working on, and I don't know how it happened with the mismatch of the titles of the names when I uploaded the files, but it was a clerical error. So,
So your clerical error caused him to incur costs to defend against it.
I suppose it did.
Mr. Cooper, you would like to be heard further?
Just regarding Mr. Crunchy's claim of a clerical error, Your Honor, we raised this issue in our answer all the way back in October. Mr. Crunchy had an opportunity under the court rules to amend his pleadings, bring in an attorney at the time. He chose not to. Instead, he sent this response in opposition to defendant's motion to dismiss, which now he is claiming is also in a clerical error. However, Mr. Karachi signed this response in violation of MCR 1.109E6.
Tell him what that actually means.
I beg your pardon?
Tell him what that means, because he probably doesn't know what you're talking about.
Well, I did speak to that in my reply brief. What MCR 1.109 E6 or E5 says that the signature of a person filing a document, whether or not represented by an attorney, constitutes a certification by the signer that, under Section B, to the best of his or her knowledge, information, and belief, formed after reasonable inquiry, the document is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. And the document is not intended for any improper purpose, such as to harass or to cause unnecessary delay or needless increase in the cost of litigation.
Really, that last clause is where you're at. It's a needlessly cost.
Exactly, Your Honor. And the immediate next subsection states that if a document is signed in violation of this rule, the court, on the motion of a party or on its own initiative, shall impose upon the person who signed it, a represented party, or both, an appropriate sanction, which may include an order to pay to the other party the amount of the reasonable expenses incurred because of the filing of the document, including reasonable attorney fees.
Which is where we're at.
Yes, Your Honor.
All right, I've heard enough, and I'm going to rule in favor of the defendant with respect to both of the issues, both in terms of the motion to dismiss it, and it's going to be granted because the party, this is not really before the court. And I'm also going to find that there are costs that should be allowed by the court pursuant to the court rules because of the needless costs that were incurred because of having to file the response that were filed and to even have this matter before the court today. So, did you prepare a proposed order?
Unfortunately, Your Honor, because there were a number of things, I did prepare one order, but it doesn't include the dismissal of the other counts for separate reasons. I plan to submit that under, I believe it's the 7-day rule.
Or you could just modify what you brought to see if that'll work.
I don't think that will work here. Okay.
Well, you have 7 days to get that in. Mr. Karachi, sir, do you understand what's going on?
For the most part, Your Honor, but I can review it afterwards.
So he's got 7 days to submit a proposed order, and that order is going to also allow for him to be able to claim attorney's fees as well as his filing costs and any incidentals that might have been occurred as a result of having to respond to the motions. Okay.
Okay.
Or to the motion, I should say. Okay. You have any questions before I let you go?
I do not, Your Honor.
Anything else for the record, Mr. Cooper?
That's everything for me, Your Honor. Thank you very much.
All right, the motion is granted for Mr. Cooper on both of the issues, and he will prepare a proposed order for my signature.
And I'll also reach out to the civil clerks to schedule an evidentiary hearing for the amount of the attorney fees, Your Honor.
Well, you should probably talk to Mr. Karachi and see if he's willing to agree to it before you have him. Because just so that you understand, Mr. Karachi, if he has to argue that, then he can technically get the cost of both the filing fee for that, as well as having to come to court to make that argument. So I'm trying to get him to not do that part because it's just going to require that you pay more money than you're already going to have to pay.
Okay.
So get a chance to talk to him. Yeah, if you get a chance to talk to him, you can work it out. It's probably going to serve you better than having to come to court to see me. Okay?
Okay, Your Honor. Your Honor, may I ask Mr. Cooper something?
Well, you can ask him to give you a call.
Yeah, that's fine. If you can give me a call. So
Does he?
I do have Mr. Karachi's phone number. We've spoken on the phone and we've exchanged a couple of emails. Certainly we'll be in touch following this.
He said he will certainly be in touch with you.
Wonderful. Thank you so much.
All right, Mr. Karachi. Thank you, Mr. Cooper.
Thank you, Josh.
Thank you, sir.
Thank you.
Thank you, Your Honor.
All right, sir. Go ahead.